Everyone make sure your cell phones are off, that there's no talking and no reactions to anything that's said today, please. Thank you. All right. This correspondence, please, is now in session. The Honorable John Durkin presides.
You may be seated.
Good morning or good afternoon, Your Honor. We're here in case number 15 CR 893, State of Ohio versus Joseph Yurich. We're set for sentencing today, Your Honor. The defendant, by bench trial, was found guilty of vehicular homicide, a violation of 2903.06A3A, a misdemeanor of the first degree, and failing to stop after an accident, a violation of 1547.10, also a misdemeanor of the first degree. I do have both victims in the courtroom today, Your Honor. However, just Jenny Cuppet, Brian Cuppett's wife, would like to make a statement to the court. Thank you.
For the past 2 years, I have lived with a lot of pain, sorrow, and anger. Now I get the opportunity to vent and release all of these ugly emotions. In doing so, I hope to start the healing process for my family and I, to obtain some peace in my life and hopefully eventually find forgiveness. I cannot carry this bitterness inside of me for the rest of my life. The court will not permit me to say what I would like to express to Joe Yurich, his wife, and their attorneys. Words like perjury, deceit, and coward first come to mind. Since this accident, I have had occasion to hear that Joe is an arrogant man who drinks too much. And as far as his attorneys go, they used every trick in the book to guarantee that a guilty man would be set free. They deliberately delayed the case for 2 years so that the witnesses would forget. They had the BAC declared inadmissible, and they advised Joe to eliminate a jury. I feel as if the defendant was the only one who had any rights in this case, as my husband certainly did not. I find the judicial system simply appalling. I do not know how these people sleep at night. One day they will all be held accountable in front of the Judge Almighty. I met my husband when I was 14 years old. We were together for 30 years and married for 23. He was a good, decent family man. He was what you would call old school. He had morals and values. He was an easygoing, friendly man who never met a stranger. He would have never drank alcohol while operating a boat and would have never left 2 injured men in the water. Joe Yurich will never measure up to the man my husband was. He simply does not have the character. Right after Brian's death, there were many nights while driving home from work that I could barely see the road ahead of me due to all of the tears streaming down my face. I would often think that all I had to do was jerk my car over into the left-hand lane while a semi-truck was approaching, and I would be free of this pain and suffering. I would be reunited with Brian, and this nightmare would be over. But then I would think of our son and realize that I had to find the strength to dig myself up out of this dark hole and make a life for us. My family is now broken and will never be whole again because of Joe Yurich. Words cannot express the amount of pain and suffering my son and I have experienced over the past 2 years. I hope Brian's death haunts Joe for the rest of his life. All the good that Joe thinks he does will never compare to the damage he has done. He killed another human being, left him for dead, and then lied about it. The verdict of this trial is infuriating because justice was not served for my husband. We all know the truth about Joe's blood alcohol levels. I believe 0.152 was the level the toxicologist reported, which is nearly double the legal limit. But yet Joe sat on the witness stand and, while under oath, deceived everyone by stating he only had a couple of beers and 2 shots. He knows the truth, and so does God. If it were not for the incompetence of the Portage County Sheriff's Department, I believe that Joe would have been convicted of aggravated vehicular homicide and assault, and he would receive the sentence he deserves. The Portage County Sheriff's Department handling of the blood evidence led to the breakdown of this case. Their error regarding a critical piece of evidence prevented Joe from receiving the proper sentence. I find it somewhat ironic that the most critical piece of evidence that we needed for conviction, the blood alcohol, was found to be inadmissible and thrown out of court. I can't help but wonder if something fishy was going on somewhere behind the scenes. Once again, the defendant was the only one who had any rights in this case, while my husband's rights did not count. Joe admitted while under oath that he has received psychiatric care and experiences flashbacks from his tours while in Iraq, all of this while drinking large amounts of alcohol. Is this the type of person that should be trusted to safely operate a boat at night at a high rate of speed? Is this the type of man you want as your surgeon? Is this the type of surgeon you want to operate on you or your loved ones? Maybe some mental health counseling should have been the priority over alcohol in the boat. Joe needs to act like a grown man and step up and accept responsibility for his actions instead of cowering behind his attorneys. The decisions he made on the night of May 8, 2015 took the life of a loving husband, father, brother, son, and uncle. We are taught that our actions have consequences. Joe needs to suffer the consequences for his actions by going to jail. Plain and simple. Every one of us here knows deep down inside that a jail sentence is the only right thing to do. Joe killed a man. After all, it was not just a simple traffic violation. Joe will get to go home from jail, whereas my husband will never get to go home. I believe that the court should sentence Joe Yurich to the maximum jail time allowed for each guilty offense that he was convicted of, and that each offense should be served in a consecutive manner. Thank you.
Your Honor, for count 1, the vehicular homicide, the state would ask for 180 days jail, a $1,000 fine, the class 4 driver's license suspension for 5 years, and then on the count 5, failing to stop after the accident, the state would ask for 180 days jail consecutive to count 1, another $1,000 fine, and the boating course that mentions in the statute with regard to that count. Your Honor, the defendant knowingly left the scene in this case, and we're asking for consecutive sentences because there are 2 victims, one for count 1 and one for count 5. The defendant has not shown any remorse, as the defense is laid out in the sentencing memorandum that was filed with the court. In fact, he didn't come to court during these 2 years that this case has been pending. He made excuses and didn't come to any pretrials and didn't want to be on camera. He has not shown good character, as the defense memorandum lays out. Being a doctor doesn't mean he's a good person. In fact, in this case, he stopped and yelled at the victims and then lied on the stand when he had the chance to tell the truth. He negligently drank to excess, an alcohol level that we later learned was 0.152 and then suppressed on a technicality. And he negligently drove 2.5 times the speed limit in the dark in a boat. And he still denied doing anything wrong. He also wants to talk about, in the sentencing memorandum, about his military experience. From my speaking with his sergeant or major in charge, he hasn't gone to any drills or anything for 2 years. So any military consideration should be moot. He hasn't even done what he was supposed to do for them. There's no evidence, according to them, that he's going to reoffend except if he drinks again. And there's been no evidence to say that he's stopped doing that. The defendant wanted to talk in his sentencing memorandum about PTSD again. During the trial was the first time the state learned about PTSD, and he attempted during the trial to make himself an expert and attempted to use that excuse. The court obviously denied that during the trial and he didn't get to use that. The defendant's wife also attempted to say that he was home before the calls came into 911. And we know from that time frame and from when the calls came into 911, he couldn't have been home at 12:05 to what she testified to. The defense also mentions the civil action in their sentencing memorandum, and we'd ask you to take no consideration of the civil action in this case. It has no bearing on what this case bore out. It was settled without admitting any wrongdoing in that case. The letters that the defense has included in their sentencing memorandum don't include anyone from that night. There was no one who witnessed him drinking that wrote a letter. Some of those people testified, and you could tell by their testimony that they were minimizing his alcohol content because he himself said he had 5 drinks. None of the people who wrote letters met the Joe Yurich that killed Brian Cuppett that night, that stayed long enough to yell at Bruce and then took off like a coward. None of those people saw him drinking those 5 drinks within 45 minutes and hop in a boat going 2.5 times the speed limit at night, a night that the defense described as very dark so that he could hurry home to his wife. We'd ask you to impose the maximum consecutive sentence, Your Honor. The defendant has no credit for time served.
Thank you, Your Honor. We do have present Dr. Peter DeVito, who wanted to speak on behalf of Joe Yurich today. I didn't know if you wanted him to come up first or after I go through the factors. Dr. DeVito?
Afternoon. It's a privilege to be here, and it's an honor to discuss with you the Joe Yurich that I know, that's an asset to our community. I've known Joe for over 12 years. First met him when he was a medical student. I am an associate professor of surgery at Neomed, and as a student, Joe was bright and eager and a hardworking student. We chose him as a resident at St. E's, where he spent 5 years, and I did hundreds and hundreds of cases with Joe Yurich. I can tell you that Joe Yurich is one of the finest surgeons in this community. If I go to the emergency room in the middle of the night, I hope Joe Yurich is there. He is talented, he is patient-centered, he is professional, he is ethical. When I personally needed time off because of a rotator cuff tear, I signed out my practice to Joe Yurich for 4 months. I received letters, telephone calls, just what a great job he did. When I came back, Joe helped me, and he covers me. He's a wonderful father. He is a tremendous surgeon. He is an asset to St. Elizabeth's Boardman, St. Elizabeth's Downtown, Northside, and Southwoods. He's in private practice. He could have gone anywhere in the country with his talents, but he chose to stay here. He's from here. He's a wonderful, professional, ethical surgeon. On a personal note, I've been out many nights with Joe. I've been to department meetings. I've never witnessed him being drunk, not in those scenarios. He has always been professional. I've witnessed him refuse drinks because he was taking call. Joe, as I said, if I'm sick, I hope someone with his talent, I hope he's there because he performs admirably. When you talk about professionalism in surgery, we can point to a lot of unprofessional things in this community. You cannot say that about Joe Yurich. Joe Yurich puts patients first, communicates with families. He doesn't care if a patient has insurance or not. I've discussed this with him. I've discussed this with his partners. I'm proud to say that Joe Yurich was a student, he was a resident, and he's a colleague. Thank you.
May it please the court. We're before you for sentencing on 2 misdemeanor offenses, and it really is a case that is difficult to encapsulate what justice means. I would like to address a couple matters raised by the prosecution that quite simply were blatantly false. Joe Yurich was here for every pretrial. He was required to be here. I believe he was excused from one pretrial because we had to reset it at the last minute because the court was in another trial and we bumped it from one day to the next. But otherwise, he has been here with his wife for every court hearing. He did not disregard coming to court. The first time the prosecutor claims to have heard about the post-traumatic stress disorder was in trial, and the court is aware, and I want the court to recall the multiple efforts made to communicate with the Mahoning County Prosecutor's Office about this case. I made multiple phone calls, I sent letters. My co-counsel made multiple phone calls and sent letters. We wanted to sit down with the prosecutor. We wanted to talk to them about Joe's military history and his diagnosis of PTSD. Those phone calls were not returned. The letters were not responded to. We had one conversation with Paul Gaines where he said, "Oh yes, I got your letters, I'll get back to you," and never did. Certainly, we respect this court's verdicts, and solely in response on mitigation, we have a letter from Dr. Christopher Seaman, Defense Exhibit 168. He began treating Joe Yurich in May of 2015 after this boating accident. Joe had had no other symptoms of PTSD or no flashbacks prior to this boating accident. He was distressed that he could not recall what happened afterwards and began seeking counseling. He was diagnosed with PTSD, and the reason this is important to bring up is not because we're trying to play on sympathies or capitalize on his service. There are guidelines for imposing a misdemeanor sentence that specifically direct this court to consider military record and any conditions that may have contributed. The finding that Joe knew or should have known there was an accident, and that he certainly, once he was driving home and realized something had happened, should have gone back, is one that we respect, and Joe certainly has felt the same way over the past 2 years, that once he realized, where am I and what's going on, I clearly hit something, he should have gone back and did not. But that does not diminish his service and what he has experienced. And with all due respect, unless someone knows someone who's been in the military, has talked to them about their experiences, it's simply impossible to comprehend, respect, or understand what happens to members of our military when they are deployed. In this instance, Revised Code Section 292922, FNG, contain factors with regard to military service that are to be considered when imposing a sentence. In this case, there are 165 letters that were written on Joe Yurich's behalf. The prosecutor's right. No one else was there that wrote these letters. But you know what? What these letters reflect is that long before that accident happened, long before he knew he would need people to step up and come forward on his behalf, Joe Yurich led the type of life that most of us wish we could. 165 people on 4 days' notice blew up our fax machine. I got a phone call during the trial from one of his patients wanting to come testify, and I did not call them back during the trial. I called them back after the trial and apologized, and I promised him I would convey this to you. When I said to him, "You couldn't come in and testify about Joe's character during the trial, but we'd like you to come forward now. Is this a good time to talk?" His response to me was, "I'm sitting in the hospital. I've had over 27 surgeries." And I said, "I'm sorry, I didn't mean to bother you." Mr. Degnan said to me, "You're not bothering me. I'm more worried about Joe than I am myself." He was released from the hospital 2 days ago and drove from the hospital to my office to write a letter. He said to me, You need to let these people know who Joe Yurich really is, because that's not been portrayed in the past 2 years. He is a man who is humble, who serves. Long before he knew he'd be standing before you in sentencing, he was humble and served. Mr. Degnan conveyed to me the first time he met Joe Yurich when he was sitting in the emergency room at the hospital. He had already had over 20 surgeries and he was in extreme pain. Joe was the surgeon on call that night. And when he came in, Mr. Degnan couldn't even talk. He was in so much pain. And Joe saw he had not had any of the CAT scans or tests done that he needed to have surgery. And he told me he did something no surgeon has ever done. He personally took me down for the CAT scan. He personally undressed me. The CAT scan was performed, and he personally took me right to the surgery. That's not an arrogant person. That's not a person who's thinking, gee, someday I might be in court and need someone to step up for me. That's someone who has genuinely lived a life of service to other people. The letters go on and on. I don't know how many of them you've had an opportunity to read, and I certainly will not quote from all of them. But letter after letter talks about a man who will give you the shirt off his back, a man who is humble, giving, compassionate, dedicated, hardworking, kind, gentle, always puts others before himself. Those adjectives were used in more than half of these letters repeatedly. They reflect a man who recognizes his obligation on this planet to make it a better place. What I found really interesting is the number of letters that came, certainly family and friends, patients that appreciate him, but nurses and co-workers at the hospital who said consistently in letter after letter after letter, Joe treats everyone with kindness and respect. Even when things are tense in the operating room, even when things don't go as scheduled, unlike any other doctor, he talks to the nurses and staff as though they're just people. Never demeaning, never derogatory, never loses his temper and blows up. Now, we've all met doctors who don't meet those characteristics, but to consistently have this many nurses and colleagues come forward and say, he talks to everybody that way, with respect and dignity. He treats everyone as he would treat his family. That's a rare thing, and that shows a beautiful character. There was some discussion today about the technicality on the blood alcohol test. If you'll recall, and this is Defendant's Exhibit 167, when we filed our reply brief, the first time we had heard that the state of Ohio failed to refrigerate the blood samples for over 62 hours was in the suppression hearing, when Lieutenant Johnson testified to that. And at that point in time, after the hearing, we had briefed the issue and indicated we had retained an expert. Contrary to Dr. Perch's testimony, when you do not refrigerate blood samples for over 62 hours, a fermentation process continues. There is a reason state law requires refrigeration, and that is because the integrity of the sample is diminished. Dr. Bellato, in his letter, outlines when he was retained, that he reviewed Dr. Perch's testimony, and that it's simply not accurate. That anytime you have a blood sample that is not refrigerated for that long, the fermentation process creates and releases chemicals that would mimic alcohol upon testing. So the .152 not only technically did not comply with the law, but scientifically it was not a reliable sample. And interestingly, and I think important, a urine sample was taken as well that night. We've heard nothing about it. Did that urine sample convey a more accurate reading that was below the legal limit? Did it just disappear? We don't have it. The court properly granted the motion to suppress that .152, but Dr. Bellato's letter and correspondence to you conveys why that reading is not accurate. So when the court considers the principles and purposes of misdemeanor sentencing as laid out in 2929.21, It's to protect the public from future crimes and to punish the offender. And the law gives you discretion to consider not only the factors listed in 2929.22, but numerous other factors are permitted, anything the court deems relevant. We're not going to go through what was in the brief with regard to those factors, but in mitigation of sentencing, in addition to what has already been presented to the court with regard to Joe's military record, he has been to Iraq twice in 2009 and 2011, to Afghanistan in 2014 in the forward surgical team. He has served in designated imminent danger areas. He has received the following awards: the Iraq Campaign Medal with 2 campaign stars, 2 Army Commendation Medals, the National Defense Service Medal, the Global War on Terrorism Service Medal, the Army Service Ribbon, the Armed Forces Reserve Medal, and the Afghanistan Campaign Medal with Star. Joe was set to be deployed last August, and with the charges pending, he was not deployed. But last summer, Joe was recommended for a promotion to Lieutenant Colonel. He did not complete the paperwork for that promotion because of these pending charges. I'm not sure what Ms. Cantala Mesa was speaking about, Joe not doing what was required. What is required when you are a surgeon that has enlisted is that when you are called, you are given short notice. You are told where to report and when you will be deployed. There is no typical training, reporting. That's not how it goes. And the problem with our military right now is we're having trouble getting surgeons who are going to step up and volunteer and go into war combat zones. So there's been nothing he's been ordered to do for our military that he has not, including his 3 deployments. There are in the letters that you have received a letter from a major who served with Joe, who said he and Joe don't consider themselves heroes. They consider themselves serving the true heroes in our wars. A friend, Exhibit 30, who has known Joe since 1999, said he couldn't understand why he would go into the military with family and with a medical practice. And then he says, I knew the answer. That's who he is, a selfless giver to everyone around him. A fellow physician who has known Joe since he was 18 said Joe had a burning need to show support to the men and women who preserve our freedom on a daily basis. Most people make a donation. Joe went there to take care of our soldiers defending our country. There is a reason the misdemeanor sentencing guidelines permit the court to consider military service. It is because the men and women of our nation who serve our nation deserve consideration for that, even when they're standing before you having committed a criminal offense. This is certainly not an individual who you need to protect society from. This is an individual, from the moment that he realized another life was taken, showed genuine remorse. If you look at the letters from coworkers and friends who have been with him the past 2 years, you see statements like, his grief and remorse is apparent daily. He lives daily for the rest of his life thinking about what happened. What happened and the life he took is in the forefront of his mind every day. Multiple people wrote to this court and said, no sentence will punish Joe more than he has been punishing himself daily. Not a day goes by that Joe is not reminded of the life he took, and the remorse he feels is genuine and true. No, long before he knew he needed people to come forward, they watched and they observed a man who gave tirelessly, humbly to those around him. One of the things the court is permitted to consider in misdemeanor sentencing is impact on the community. Multiple letters from patients, colleagues, and coworkers noted the devastating loss for patients that would be experienced if Joe was incarcerated. It would deprive our community and patients of compassion and talent and would not be justice. He takes uninsured and non-paying clients. Several other doctors commented on that it doesn't matter if he's getting paid, and that for Joe, it's not about making money. It's about helping people in need, and our community would be greatly deprived of such a physician with such talent and such compassion. Today, we submitted additional records or letters to you because the fax machine kept blowing up. Exhibit 161 is from an RN who gave several accounts of where she has seen Joe selflessly give to those around him. But she gave one particular account of an intravenous drug user who was going to lose his arm, and no other surgeon would touch him. As she put it, everyone else wrote him off because of his history. Joe came in, talked to her, met with him, and agreed to do the surgery, saved his arm. And she points out that Joe is that type of surgeon who, when no one else will step forward, when people are hopeless and at loss, he steps up to try to help. Countless letters outline the benefit to our community from his presence and the harm that would be caused by incarcerating him. Many letters cite that he could do more good out and that there are other forms of punishment besides incarceration that should be considered for Mr. Yurich. The court should know that the State Medical Board, after this accident, did send an investigator, and pursuant to their request, Joe underwent an alcohol and drug assessment at Glen Bay. No issues or concerns were noted. He has been permitted to continue his practice and operation since that point. Patients want him as their doctor. There are more than a dozen letters talking about how patients don't want to reschedule with another surgeon, have been calling with their prayers and asking if he will be available for them. As a criminal defense attorney, we hope, I think it should be one of our jobs, to try and have a positive impact on our clients. It is one of the rare opportunities I have had where my client has had a positive impact on me. Watching him over the past 2 years in how he has conducted himself, in how he has shown genuine remorse, and yet maintained his focus on everyone but himself. He has been an inspiration. He has been the type of person, as I started out saying, that we should all wish and aspire to be. Many of the letters pointed out that what happened that night, in that split second, does not define who this individual is. And I submit to you that what happened in that split second should not define Joe Yurich and should not be the only factor considered in imposing sentence. The misdemeanor sentencing guidelines permit this court to consider all relevant factors, and we outlined them in our brief. I submit to you that this individual has much more to continue offering to our community, not just as a surgeon. There are other sanctions that are appropriate that Joe could participate in to make a difference from this tragedy. I know Joe wanted to address the court, and if the court permits, he can do so now.
Thank you for the opportunity to speak, Your Honor. I accept full responsibility for the events in the accident on May 8, 2015. I respect the court's decisions and judgments in all these matters. I understand that my activities and my actions have negatively impacted multiple families. I am truly sorry. Not a day goes by where I don't feel remorse or sympathy for the families involved. I think about Mr. Cuppet. I think about the descriptions of him being a father, a husband, a friend, the kind of person that I aspire to be. I know his loss has been a huge impact to his family. I think about Mr. Lindemood. I think about how his life has changed forever that night. Despite his feelings during the trial, he was able to show compassion towards my wife with kind words and gestures. Those things don't go unnoticed, and that is a true attribute to his character. I will never forget the consequences of my actions or forgive myself for the pain that I've caused these good people. I only hope to continue to serve my family, my community, and my country. Thank you.
I spent a great deal of time in court last week setting forth my findings of fact and conclusions of law that led to the verdicts that were returned. So I'm also, for the benefit of everyone, going to spend some time this afternoon summarizing the law that I must apply and the reasons that will form the basis for my sentence. As both counsel have indicated, the defendant was found guilty of negligent vehicular homicide, failure to stop after an accident, both misdemeanors in the first degree. Sentencing options for both offenses range from community control, a fancy term for probation, to local incarceration of up to 180 days on each count, a fine of up to $1,000 on each count, and a Class 4 license suspension. Counsel has provided the principles and purposes for misdemeanor sentencing, and quite frankly, we don't get a lot of misdemeanor sentences here. So I have spent a great deal of time going through those factors that the law requires that I consider before I impose sentence for these offenses. The overriding purposes are to protect the public from future crimes by the offender and to punish the offender. To achieve these purposes, I must consider the impact of the offense upon the victims, the need for changing the offender's behavior, including rehabilitation, if necessary, and restitution. Revised Code Section 2929.21c provides that before imposing a jail term as a sentence for a misdemeanor, the court is required to consider the appropriateness of imposing a community control sanction or a combination of sanctions. As I said when I announced my verdicts, justice certainly would mean having the ability to turn back the hands of time. Justice today must unfortunately be handed down in a far different and unfortunately far less satisfying manner. I can say from the outset in my 20-plus years serving as a judge that this has been one of the most challenging and difficult cases that I have presided over. That's primarily because the majority of cases where there is a tragic loss of life involve defendants who intentionally or purposely cause the death of another. And frankly, when someone is convicted of that type of offense, sentencing is rather straightforward. Neil Cuppett tragically died on May 9th, 2015. And we've heard briefly during the trial this afternoon from Mrs. Cuppett a little bit about what type of man, husband, father, brother, son, and uncle that he was. And the impact of the offense upon the victims cannot be understated. And quite frankly, the easiest thing for me to do today would be to simply follow the state of Ohio's recommendation and impose maximum consecutive sentences and fines that would total 1 year in the Montgomery County Justice Center. But before I would be able to do that, I must consider other factors, specifically the nature and circumstances of the offense. And as I said, as the trier of fact in this case, there's certainly no need to recount those this afternoon. Whether the offender has a history of persistent criminal activity that would reveal a substantial risk of reoffending. I don't believe that there's anything in the record that would indicate any prior criminal history or activity. Whether the offender would be a danger to others demonstrated by a pattern of repetitive, compulsive, or aggressive behavior. And again, I don't see anything in the record to indicate that. An emotional, mental, or physical condition traceable to the offender's service in the armed forces, and that was a contributing factor. Again, I've had an opportunity to hear testimony and evidence in this regard, and I've issued my verdict based on that evidence. But it is a matter that I will briefly review the exhibit from Dr. Bellato and Dr. Seaman. The victim's youth, age, or disability were not factors. There are certain tests known as risk assessments that assist prosecutors, defense attorneys, and the court as it relates to someone's risk of recidivism. And some of those include prior criminal history, age, education, employment, and based on, quite frankly, Ohio's risk assessment, I do not believe that the offender is likely to commit a future crime, which is the sixth factor. And the final statutory factor I must consider is Mr. Yurich's military service record. As it relates to the state of Ohio's request to impose maximum consecutive sentences, that can only be done statutorily in two instances. One, if this was the worst form of the offense. Or secondly, if the offender whose conduct and response to prior sanctions for prior offenses demonstrate that the longest term is necessary to deter the offender from committing future crimes. And as tragic as this case is, I do not believe legally or factually that it falls into the category that one would classify as the worst form of the offense. And as I've already stated, the second factor is not met since the defendant has no prior criminal record. And as a result, even if I wanted to, I do not believe that I could legally impose the longest jail term in this case. In considering the overriding purposes of misdemeanor sentencing, because the factors are not present regarding any risk of recidivism, the remaining overriding purpose of misdemeanor sentencing is to punish the offender. And I need to address some things that were stated as it relates to the blood alcohol content, because quite frankly, I think that is the elephant in the room. Laws are there for a reason. A suppression hearing is held. The detective from Portage County clearly did not follow the requirements of the Ohio Administrative Code, and I had no option legally but to suppress that evidence. I'm not certain as I sit here, although the results were a .151 or 152, whether or not that result would have changed if the sample had been refrigerated. The Administrative Code is written for a reason, and there are certainly varying expert opinions now as to what that actual BAC would have been had that law been complied with. But I did what the law required, and I certainly cannot consider and should not consider the fact that that evidence was suppressed in making my decision about what justice requires or about what the misdemeanor statute dictates that I must do. But there's no question that your actions in operating your boat at speeds between 20 to 25 miles per hour on Lake Berlin, late at night, directly caused no couple's death. Although statutorily I was obligated to find you not guilty of aggravated vehicular assault, clearly Bruce Lindenwood is a victim as it relates to failure to stop after an accident, and your actions directly caused Bruce to be thrown off the boat and fortunately survived. I'm convinced that but for your speeding, your cover would still be alive. And that's something that everyone in this room has to carry. And I will say personally, having sat through many of these types of cases, that I hope with time that the victim's family can reach the closure and get some sense of peace. Although life certainly will never be the same with the loss of your loved one. As it relates to failing to stop after an accident, the two things that cut in your favor are that your wife called 911 and a detective was dispatched to your home that evening, certainly in time for the BAC to be admitted into evidence of being done everything else that you should have done. Secondly, and perhaps more importantly, is that even if you had stopped, the coroner testified that no one, including you, could have taken any medical action to save his life. As far as litigation, I've read the sentencing memorandum submitted by the defense, which included now over 160 character letters. And quite frankly, the sheer number of letters was not necessarily persuasive, although I don't think I've ever seen that many. But what was impactful is a recurring theme, and it's clear from everyone that had contact with you, from teachers to family to neighbors to acquaintances to nurses and doctors and patients and veterans who served with you, that according to them, your actions on May 9th were out of character with who you are and what you have done both personally and professionally and in your service to this country. These mitigating factors do not mean that you should not be punished. The question is what punishment is appropriate, given everything before me. Punishment in the criminal justice system certainly takes many forms. And I believe that balancing and utilizing these options will hopefully accomplish the overriding purposes and principles of sentencing. So considering the factors that I mentioned earlier, it is the sentence of this court that you serve 6 months in the Mahoney County Justice Center for the offense of vehicular homicide in count 1, and 6 months in the Mahoney County Justice Center for the offense of failure to stop after an accident in count 5. I am going to suspend 170 days in count 1 and 180 days in count 5. I am ordering 90 days of home confinement with electronic home monitoring, allowing privileges for your employment. I am placing you on 5 years of community control to the Community Corrections Association. As a specific term and condition of community control, I'm ordering that you perform 200 hours of community service that will be done at the rescue mission, where you can provide medical care and treatment to those individuals in our community who are in need of that care. I am certain some may say that you have been given preferential treatment because you are a doctor. The truth is that the letters included in your memorandum indicate that you have saved many lives as a surgeon, both in Iraq and Afghanistan and here in our community. And quite frankly, if you have the opportunity to save even one life while in community control as a result of this sentence, I believe that to be justice instead of, quite frankly, working in the kitchen while in jail. And I hope that this sentence comes as close to possible as rendering what I believe the statute requires. Attorney Counsel has indicated that I should not consider civil litigation, although I am required to consider restitution. It's my understanding, and correct me if I am wrong, that the civil litigation did in fact address the issues of restitution, say, except property damage to the past master.
That's correct, Your Honor. That has been paid and satisfied in full.
With respect to the property damage, obviously there would be an order of restitution to satisfy that.
There is a pending civil action, and I spoke with the insurance attorney today. Over a month ago, they extended an offer to resolve that property damage claim as well. That has not been responded to by the plaintiff's attorney.
As it relates to the Class 4 suspension, I'm going to impose a driver's license suspension of 1 year with occupational driving privileges after 45 days. And I reached that decision because this is an offense that did not occur with another vehicle or with the water crime. I'm not certain you're ever going to get out of the boat again, but I am also going to order the educational watercraft safety courses required by statute. I'm going to impose a $1,000 fine suspending the cost. From this verdict and sentence, you do have a right of an appeal if you should decide to do a verdict or sentence. I would ask your counsel to take whatever steps are necessary to perfect that appeal. Is there anything further from counsel?
No, Your Honor, thank you.
No, thank you, Your Honor.
All rise. This court is in recess.